heard the term, where there's a will, there's a way? Well, I am going to rewrite that. Where there is no will, there are way too many relatives looking for money. Did you know a shocking 50% of people die without ever writing a will or trust? That does not mean they don't have a will, they do. It's just drafted by the state, and their assets will go as the state intends, which may not be as they intended. The state will decide who is in charge, and their assets become subject to taxes and claims and creditors in a very public way. This never needs to happen. Hi, I am an attorney, Eileen Kerlin Walsh, and today I'm going to talk to you about what I call the Essential Six. 6 documents every responsible adult should have in place to protect themselves and their loved ones, to avoid court involvement, preserve family harmony, and preserve their own personal legacy. But first, I'll tell you a little bit about me. As you may be able to tell from my voice, I grew up in Ireland, one of 12 children, 6 boys and 6 girls. We lived deep in the Irish countryside with my parents, an elderly aunt, 15 of us on a small farm in a small farmhouse. It was a traditional, old-fashioned, rural Irish Catholic childhood. It probably sounds like something from 100 years ago, but truly, it was only 50. I first came to the US in 1989 on an exchange program. I fell in love with Chicago and caught fire with the American dream. I came back as soon as I could, finished my degree at DePaul, and went to Loyola Law School. Straight out of law school, I tried cases for the Will County Public Defender's Office. It was an exciting assignment. I gained valuable litigation skills. I remember one Friday night in particular, we had tried a case. It was with the jury. The judge would not allow the jury to adjourn at 6 p.m. and sent them back to continue deliberation. We got word at 9 p.m. the verdict was in. I remember walking up those steps to the courthouse in the night air, past the eternal flame, and feeling overcome with exhilaration. That simple little country girl was a trial lawyer in the United States. I had just cross-examined witnesses, delivered a stirring closing argument that I had rehearsed in the shower all week, and was going to take my place at counsel table. As the jury filed in and the verdict read, it was straight out of a movie. That feeling of that moment still lives in me vividly. The cool night air, the burning flame, and the realization that with grit, tenacity, and hard work, dreams really do come true. Even though my time with the Public Defender's Office was a tremendous learning experience, there was something about the adversarial system that did not sit right with me. I went out into private practice. I discovered estate planning, just a fancy name for wills and trusts, and there I found my home. I love estate planning. I love you. I love your stories. I know why estate planning is hard, why you put it off. It's difficult to talk with a stranger about your money, your property, what you have, what you might have lost. It's hard to talk about your family, the pain of an estranged daughter, a son with mental illness, maybe addictions, someone with autism, a spendthrift, someone getting a divorce, perhaps getting state or federal assistance. It's also hard to choose one family member over another for executor trustee. What do you do about the loan you gave the struggling child? If you forgive it, how will the others feel? What about the adult child living at home? What do you do to protect a blended family? The glory of estate planning law is we have solutions for every one of those problems. Your family situation is far more common than you think. I take what can be a difficult or daunting experience and make it easy and comforting. I take that huge weight off your shoulders and guarantee you peace of mind. I read a bar article once that divided lawyers into warriors and healers, and I thought, that's why I didn't belong in criminal law. I am not a warrior. I am a healer, and that's exactly what we do with estate planning, which I am steeped in. I take my legal education every year in estate planning. I have hosted a TV show in the Southwest suburbs since 2011 focused on the subject. I write a newspaper column, a magazine article, and I have had an estate planning practice for over 20 years now. So today I'm going to share my knowledge with you, show you how to avoid the perils of poor planning, that mess left behind that I know either you have experienced or heard a friend, family member, someone in your church describe. I will show you how to leave your affairs in order. That, I can promise you, is the greatest gift you can give yourself and the best possible legacy you can leave your family. Those essential 6 are your last will and testament, usually a trust, power of attorney for finances, power of attorney for healthcare, end of life instructions, your living will, and an ethical will or legacy letter. A legal will is the foundation of all estate plans. In your will, you decide who gets your money, your home, your pets, your jewelry, everything. You also decide who will be in charge. If you have minor children, you determine who will raise and educate and love them if something happens to you. At a minimum, we all need a will. You've all mulled it over from time to time. You've thought about this. So if you're the 1 and 2 who does not have one, this is your sign. It's a good time to change that and get a will in place. A will often needs to be accompanied by a trust to keep your estate out of probate. Example, husband and wife, they have a home, it's in joint tenancies, no problems upon the death of the first of them. But when the survivor passes, that home, even with a will not go to the children without probate. Probate is a court process through which a petition is filed, hearing held, executor appointed by the court, and a claims notice published. There is a lot of expense associated with probate. So I represented the family of a very successful businessman. He died in a tragic accident and he had no planning whatsoever. We determined that he had children from 3 different stages of his life. He had adult children, he had a teenager, and he had a baby. There were many different families involved. Because there was no planning, all of this played out in a very public forum. There were business corporate accounts, there were personal accounts, there were business properties, there were personal properties, there were bank trusts, there were so many different things we had to determine. The law had to determine who was going to be in charge of all of this. Turns out my businessman had never divorced from his very first wife, so now she played a role in this very public probate, which he certainly would not have intended. Claims and disputes, including paternity disputes, kept this estate open for years and costing hundreds of thousands of dollars. None of this needed to have happened if we would have had an estate plan in place. It's a public process. The assets are vulnerable to credits through the probate process, and while it's necessary for those who have done no planning at all, it isn't necessary for you. It is 100% avoidable. And the most common way to avoid probate is having a trust. Think of your trust as just another way to hold title. You can have a simple residential trust to hold your home. Create the trust, deed the property into it, name your beneficiaries. It is so simple and smooth. No mess, ever. Another commonly used trust in our community is the revocable living trust. This is a marvelous instrument. Think of the living trust as your treasure chest. Who do you want in charge of your treasure chest? That's the trustee. That'll be you to begin with, and then you choose your backup. And within the trust, you determine who gets what. But who gets what goes way beyond a will, in that you can build in lots of protection. You can protect your children's inheritance from divorcing spouses, creditors, predators. You can protect it from themselves if they need it. We created trusts recently for a young widow who her minor children were starting to turn 18. Their father had been killed in the line of duty, so there was significant funds coming to these children as they reached the age of majority. We were able to create trusts for them. Mom was the co-trustee, so she could help them manage their funds. She could help them protect those funds from creditors, predators, even themselves. We all know that 18-year-olds are not exactly in a position to make really good decisions about their finances. So that was an example of where we use trusts to protect everyone involved and save the family tens of thousands of dollars. Now, speaking of minors turning 18, we often also provide for our clients powers of attorney that the 18-year-old can give back to the parents for those additional years when they need extra help. They do still need mom and dad as they go off to college, but because they're now considered adults, we cannot get their healthcare information if they're in the hospital. We can't get their grades. We can't get their enrollment. We cannot even go to the bank for them. So I suggest that everyone whose teenagers are turning 18 make sure they get these powers of attorney for them. And I will tell you a story very recently, very personally illustrated the need for just that. My 18-year-old was heading off to Berkeley just in August, and I had prepared the powers of attorney, and he was a little, why do I need to do that? Why are you checking up on me? I said, James, we need these to help you. He's not in Berkeley 1 week until he buys a bike. He's an enterprising young man. He has decided that he is going to deliver around campus from DoorDash and make some extra money when he realizes he doesn't have his bank information to sign up for DoorDash. Mom, could you help me with my bank information? James, your account number is not on your statement anymore. Oh, can you go to the bank and get it for me? Sure, but guess what? They're not going to give me your account number without the power of attorney. So 1 week into the semester, we realized that it was valuable for me to have power of attorney for him. So for your 18-year-olds, also grab a power of attorney before you let them out of your sight. Thanks. We also can build in special needs trust planning. We can build in children's trusts, grandchildren's trusts, just whatever your family need is. You tailor your living trust exactly to your needs, and then we fund it. That means retitling your home into your treasure chest, maybe your investment accounts. We name your trust as the beneficiary on your retirement accounts, on your CDs. We may make the trust payable upon death on your bank accounts, or transfer upon death on your investment accounts. We can put your out-of-state property into your trust, your business interests. Who do you want to pass them on to? There is so much that we can do with that living trust. Save you tons of money, not just in probate, but also in property tax, income tax, estate taxes. You will still have a will if you have a living trust, but instead of saying, I leave everything to my spouse and children, your will, called pour over, would just say, I leave everything to my trust. It's simple, easily understood, and very easily administered after your death. These trusts are typically wrapped up within a few months, and your family member can handle everything with a few visits to the attorney. Recently, I had a clients who had lived very humbly. They had a very small fixed income. They were receiving some both state and federal help with their health care and their income. Then, out of the blue, the wife received an unexpected large inheritance. As pleasant as that surprise was, it now left them very vulnerable to mismanagement. The husband, who had both a physical disability and a mental illness, was a spendthrift due to the mental illness, so the money was vulnerable to mismanagement, to predators. They were both very elderly, as well as loss of benefits. We were able to, with good trust planning, get all the money protected for them. We were able to set up protective trusts. We were able to protect their benefits for both their lifetimes. We were able to help them, as well as make sure the money went where they intended after their deaths. The wife, who had inherited the money and who was very worried about her ill husband, was crying tears of joy because of the solution that we were able to offer them. We do many different kinds of trusts: special needs, general needs, IRA trusts, Medicaid trusts, residential trusts, charitable trusts. We even do pet trusts. All of these can be incorporated into your living trust or done separately. Trusts are beautiful, inexpensive, private, and protect everyone, including ourselves, and save lots of money. The next document is a power of attorney for finance. This is where you get to choose who would take care of your finances if you're still here, but unable to take care of them yourself. Even if you're temporarily or permanently unable, while you're still here, you need someone to take care of affairs. You may have a trust and there may be assets in that trust, or there's a retirement account that has to be held beneficially. That needs the power of attorney. You may have named the trust in some of your accounts, but they still need to be managed for your benefit while you are still here. Name someone you trust for the role, and if possible, a backup. This will give the authority to whomever needs to pay the bills, transfer funds for you, continue your financial life, step into your shoes if you had an accident, an illness, stuck out of the country, get dementia, Alzheimer's, or even just the diminished capacity that comes with great age. The second power of attorney is healthcare. This is so essential. I always tell my clients, my audiences, if you don't do anything else, if you continue to put off estate planning, get these simple little powers of attorney in place, because they are not about after death. They're not about who gets their stuff. These are about you and taking care of you. And if you are lucky enough to have trusted family members or friends who would step in an emergency, long-term incapacity, to take care of you, give them the authority that they need. If not, they will have to go to guardianship court. And that, my dear viewers, is to be avoided at all costs. I know that in a guardianship, no one is happy. It's a court public process. It's still expensive. It is so intrusive. The loved one has to go through all that process, explain every penny, put in a budget and an accounting every year, apply for amendments if something comes up that they need to change the budget. It is a huge impediment to taking care of you. I have planned for many same-sex families and polyamorous families. Same-sex couples now have a lot of protection that they did not have in the 90s, but polyamorous families do not have that protection yet. I planned for one family where within the relationship we had a married couple, a man and woman married to each other, plus a third partner in the relationship who needed the protection that she did not have that the married couple did have. Plus the third partner had children. We were able to create a trust that protected all three, made sure each was equally protected, and we protected the young minor children of the third partner should something happen to her. And they were delighted with the plan, not just for the legal protection that it offered them, but to that they were recognized as a beautiful, legitimate family that they were. We represent blended families all the time. We are so lucky here in the US to have second and third chances at love and marriage even into our later decades. But those blended families need a lot of protection. Yours, mine, and ours. We need to protect ours as well as yours if I die first. We want to make sure that everyone is protected. That doesn't happen naturally. We need to get the good documents in place. We need to prepare for, after either the incapacity and death of one, the protection of the other during the rest of their lifetime, and to make sure that after both partners died, all children get an equal share. Blended families can be harmonious or they can be at war, and good estate planning is what makes the difference. This can be avoided with powers of attorney. They're durable, they endure through incapacity. You give the authority to your loved one to make healthcare decisions. And you should discuss with them what you would want if the day comes you cannot make your decisions, your pain tolerance, where you would want to be, any religious or spiritual considerations, and your end-of-life philosophy, which takes us right to number 5 on my list, end-of-life instructions. Now, I don't say that everyone should have a living will like a power of attorney, but I do say if you've thought about your end-of-life philosophy, make sure your loved ones know what that is. And if you do not want to be kept alive on life support, make sure your family knows that. Get that into your documents in 2 ways. In your healthcare power, there's a section where you make the choices. Used to be 3 if you have an older power of attorney, but since 2015, there are now just 2 choices. Keep me alive regardless of the chances for recovery, the costs, the quality of life for me. It is more important than length. That's the second one. If quality is more important than length, then when doctors have determined that it's just death, delay, and procedures in place, let me go. In your healthcare power, you give that direction to your agent. And here in Illinois, we have a separate living will declaration. That's your right to die. That's your right to refuse treatment. If you also get that in place, that's not about your agents anymore. That's about you right now signing a legal document to refuse treatments when the doctors who have examined you have determined that death is imminent and that these death delaying process in place, they're the only thing in keeping you alive, and you now authorize those to be withdrawn and you be allowed to die naturally with just comfort care. You'll not be in the position at that time to give your opinion then, so you're giving your opinion now and giving it legal effect. I have had many clients say, I had to make this decision for my mother or my father. They tell it now 20 years later, still with tears in their eyes. They say, I don't want my loved ones to have to make that decision for me. So if you know you would not want to be kept alive that way, get it into your documents. Make the choice and take it out of their hands. If you don't know what your end of life philosophy is, then just don't say anything and leave it up to them to make the decision in your best interest when the time comes. Now, after you have created your plan, add a roadmap, a list of the assets that the estate plan aligns with, as well as any personal instructions. That will be icing on the cake. If you have a trust, keep an updated list of what the trust has been funded with. Deeds, IRAs, beneficiary forms, CDs, bonds, account statements. You don't have to put a new statement in every month, but maybe once a quarter or at a minimum once a year. Be careful to include insurance policies. Every year, billions of dollars go unclaimed because families did not know insurance policies existed. Online assets necessarily complicate administration of an estate because they are hard to discover and hard to access. So with your roadmap, keep a list of your digital assets with passwords and usernames. For your online bank accounts, social media accounts, YouTube, websites. Also keep your pet instructions, your healthcare providers, and important phone numbers. Most of you have gone through grief. You know how debilitating it can be. Joan Didion, in her book, The Year of Magical Thinking, after her beloved husband died, said months later she received an important paper from the hospital that had been floating around the post office because she had given the hospital an address she hadn't lived at in 20 years. So in the midst of all this planning, to leave no mess, to have your affairs in order, it is one of the greatest gifts you can give to those coming after you. I had a dear client that I helped through a guardianship for her elderly aunt. This client was at war with her brother. They both fought about who would take care of the aunt, and a judge, as judges often do, split the baby, give my client health care, gave her brother financial agency, and they never could agree on the aunt's care. They also had other lawsuits going on regarding their parents' estates. So there was very, very bad blood between my client and her brother. I said to her, we need to get your estate plan in place because we want to avoid a repeat of your aunt's disaster story for you. She said, I will do my estate plan when all these lawsuits are over. Well, life doesn't always wait until it's convenient for you. She was involved in a bad accident and her injuries precipitated her own dementia, and she ended up a ward of a guardianship with the brother that she hated taking care of her. I know that's the last thing she would have wanted. And all that could have been prevented with these two simple, inexpensive little documents: a power of attorney for finance and a power of attorney for healthcare. And speaking of great gifts for those coming after you, the last item in my Essential 6 is an ethical will, or legacy letter, as it is more commonly known. It is a beautiful rendering on the meaning and purpose of your life, made up of the stories that have made you who you are and taught you what you believe. The intent of a legacy letter is to leave your story as a priceless gift to your family, capturing forever your place in history and enriching the lives of your readers. Let me tell you my journey to use of this marvelous ancient storytelling tradition in my practice. I combine my love of story honestly. As I mentioned, I grew up one of 12 children deep in the Irish countryside. We lived with my parents and an elderly aunt in a small farmhouse. No electricity, no telephone, no TV, little outside influence. We had oil lamps and turf fires around which old people told stories. Stories of banshees, illegal whiskey stills, fairy rings, brutal oppression, cruel clergy war, hunger, uprising, and above all, survival. We listen transfixed. What I love most about my estate planning practice are your stories. As we talk, get to know and trust each other. I unwrap your needs through your stories. You tell me how you started your business. You tell me about your losses and about your successes. You tell me family secrets. You tell me your cancer story, your divorce story, your immigration story, your war story, your faith story, your birth story, your adoption story, your love story. I learn daily the stories that shaped your fortune, your worldview, and your life. I have always been fascinated by your stories and knew they were as important to your family as your possessions. Stories, of course, do not belong in legal wills, so since 2006, I have been encouraging you to include an ethical will or legacy letter as part of your estate plan. The intent is to leave the story as a gift to those coming after you, capturing your essence, that little brief bubble of who you were forever. I created a video tutorial and a workbook to help you write your legacy letter quickly and easily. I guide your memories, values, your beliefs, your gratitude, your hopes and blessings onto the page. So here are a few samples from Share My Legacy Letters. A sample of a dedication. I dedicate this legacy letter to my unborn child to let you know how much you are wanted and already loved. I will share my hopes and dreams for myself and for you. I write this to you now knowing that my perspective may change as you grow and develop as an individual and as I grow as a parent. Your father and I are becoming parents later in life with many experiences and I hope wisdom gained from them. I know we still have much to learn, but this is what I know so far and what I hope for you in the future. Another example of a dedication to the most important people in my life. I am writing this legacy letter to share some thoughts I have for you, how much I love you. As a person who has children and also a life-threatening illness, I have stopped trying to fix up you kids because my work is done in the world. I look at you with new eyes and delight in who you are. I love who you are. I want you to know that while I don't express sadness and anger about dying, I do not easily leave you. My first name is Kathleen, but my mother Lucy always called me Kate. I grew up in Newcastle, England in the 1950s. Strict family values and regimes were beginning to fade. I never knew my father. I didn't even know his last name. As far as I know, I don't have any siblings. But because I know so little about my own family, I want you to know everything about yours. I remember my mother singing Born to Run by Bruce Springsteen. She smiled and danced with me every time she sang it. My mother worked 2 jobs, and when she was home, she was really, really busy. So that meant her stopping what she was doing and dancing with me made it all the more precious. As hard as it is for you grandchildren to believe, we had fun growing up without TV or devices. Warm nights were when there wasn't any school were the most memorable. There was a gas light on the side of the street in the middle of our block. When supper was over, the kids would gather in front of the gas light. Towards dusk, the lamplighter would come up the street carrying a long pole with a light in the end against his shoulder. We kept our distance while he lit the lamp. Then we'd start. Games played on the step, sidewalk games. The girls played hopscotch, jacks, and skipping rope. The boys played mumbledy-pig, and we all played hide-and-seek together. At 9 o'clock, the curfew at Liggett & Myers Tobacco Company would sound, and all the kids ran home. There's one young woman who had a really difficult time with infertility. She writes, We were so much in love. We had everything going for us. Great careers, salaries, beautiful home, extravagant wedding, exotic holidays. The world really was our oyster. Then we decided to have a family. At first, we weren't really concerned when it didn't happen, but then I started to worry. My friends were dropping babies, even those who didn't want them. People who joked, "Isn't it time you two had a baby?" suddenly became quiet, and I noticed people seemed reluctant to share their pregnancy news with me. What followed were countless visits to doctors and fertility clinics. Injections, temperature charts became a part of our bedroom routine. I allowed my desperation to destroy our love and passion. My husband couldn't take it anymore. Infertility cost us thousands of dollars, but they also cost us our marriage. Looking back, I know I allowed circumstances to control me. I regret not getting counseling. We could have channeled our immense love in a positive way. My hard-earned lesson was to preserve what I had in life rather than risk losing it in the pursuit of something we didn't have. We often consider giving in to be a weakness. I believe, however, giving in is a strength. I once heard a high-profile divorce attorney speak at his 50th wedding anniversary. A guest asked how he managed to stay happily married when he dealt with crumbling marriages all day long. He said his secret was to give in early and often. This, too, is giving. Those words had a profound effect on me. From that moment on, I viewed giving in on decisions with my partner, my children, my colleagues to be a form of giving and therefore a form of strength. This led to stronger, more successful, and happier relationships in my life. Our family has had its roots here at Otter Creek since your great-grandpa Jack settled back in 1867. I don't expect you kids to keep the farm. I realize that even little Eddie will follow his big brother and sister to the city one day. My only hope is that the house and farm, the 15 acres, be preserved as a family vacation spot. I want you to bring your children to relax, fish, swim, and have fun pursuing life's simple pleasures. And most importantly, I want you to stick together as a family. I learned that family is where we begin and end. You boys are as close as it's possible for humans to be. You share the same ancestry, gender, parents, childhood, language, friends, neighbors, and home. This creates a bond so strong it can see you through anything life shows up with. And this bond will link you to us and each other for eternity. My honesty in this writing surprised me. It was cathartic and freeing. I hope you, my dear friends and family, are not too shocked to learn about my other son. I'm glad to carry no secrets with me as I close this chapter of my life. I hope you agree that despite my challenges, I have had a life well lived. You too will have your challenges, but also your moments of greatness. I want you to know that I believe in you and I am immensely proud of you. Love, John. Your legacy letter can be written anywhere, at any time, and completed in a weekend. You already have everything you need, a wealth of wisdom and knowledge inside you. Most of us move through life and death with little recognition, with no idea how special our story is. We read, listen, and voice the stories of others. In the pages of your legacy letter, you take center stage. Your story is the window to your soul. Your words are jewels valuable to you and others. important enough to be written and shared. We each have a unique contribution to make to what Sandra Cisneros calls the chorus of voices, brave, heartbreaking, beautiful. Our time on this earth is limited. Let's make it matter. Let's give it meaning. Let's do something noble. Create an estate plan. Then write a legacy letter. Add the warmth of your voice to your legal documents. This is the greatest gift you can give yourself and the best possible legacy you can leave your family. So in conclusion, I will finally say I devote my legal career to estate and legacy planning. After these 20-something years consulting with you in my office, your homes, hospital rooms, deathbeds, I have discovered no area of law more important or rewarding. I have also discovered my gift is guiding you through this transformative process with warmth and competence. Estate planning is the heart and soul of the law, and there is nothing now I would rather do. Estate planning is about protecting your assets, your loved ones, and planning for the future. Yes, but it is about so much more. It is about you, your unique story, your life savings, your values and beliefs, and your hopes for the future. That is what I weave into your estate plan.